Govender. Thank you.
Good
morning to the
sir.
commissioners.
Good morning. You are most welcome. As we begin with our proceedings, let me just clear some few issues with you that you have been a professor for quite a number of years.
That is correct, yes.
Perhaps for a minute you can switch off your microphone as I speak. Thank you, sir. And you have published a number of documents. You have been a chairperson presiding in certain institutions, and you have been an acting judge for a number of acting stints. It appears to me that overall you have effectively acted for a period of slightly more than 2 months. Slightly more than 2 months. Given the fact that some of the acting positions were for 2 days, for 1 day, or 3 days, for you to complete what was outstanding during your acting positions. Is that so, sir?
Justice Govender, I acted the first time for about 6 weeks, I think. And then there was one criminal trial that I had to complete. And that took me about a month or so. And in my second stint, I acted for 5 weeks the second time in 2015. That's the end of last year. So that's the composite total of the time I spent on the bench.
Thank you, Mr. Govender. I've had a look at your scholarly judgments, and I recognize that you do write well, well-informed decisions. I have had a look at the remarks by Black Lawyers Organization. They think that whilst you have written good judgments, you have not acted sufficiently for you to be considered favorably for today's purposes. Do you have a comment?
Yes, thank you. Justice Govender, I think that clearly that is a criticism. I think, though, that this decision has to be made holistically, evaluating all the things that I've done over the last 20-odd years. And I think the process of judging involves the process ability of conducting the trial or the courtroom properly and treating people with propriety and decorum. And then there's a substantive part of where you've got to resolve or determine the dispute before you. And I think as a judge, there's an additional responsibility. You've got to develop the jurisprudence so that the constitutional democracy grows. And over the last 20 years, I've written fairly extensively. I've been a senior arbitrator since 2002. And so there's a track record of my presiding over hearings. So whilst the criticism that I haven't perhaps acted enough is probably justified, I think if you look substantively at the requirements, I would argue that I actually do meet the requirements.
If I'm correct about your age, Mr. Govender, you are 56 years old now?
That's correct.
Meaning that if your candidacy is favorable, you will be a judge for the next 13 years before you reach 70.
That's correct.
Thank you, sir. Mr. JP?
Thank you, Deputy Chief Justice. Mr. Govender, the last time that you were interviewed, you hadn't done any civil work, so to speak, in the High Courts. Is that correct?
That's correct, yes.
Since then, you had an acting stint in Pietermaritzburg and that was for a period of 5 weeks.
That's correct.
Well, how did you find that?
I found it enjoyable. I found that I had to work harder than I normally worked, and I found that I was able to cope. I did, as most acting judges do, when you're in that position, you have to perform at the level required by yourself as judge president, by the people that use the courts, and by the practitioners. And I think I performed the responsibilities adequately and satisfactorily.
Was there any difference in the experience doing civil as opposed to doing criminal work that you had done before?
Yes, there was serious and material differences. With civil work, you get new work coming all the time. You have to be aware of what is going on. You have to be able to research quickly, and I think you have to be able to write quickly as well. So I found the civil part of it more demanding than the criminal part, would be my assessment.
You see, it is the writing quickly and coming to a decision quickly that I want to just press on for the moment. Your background is largely academic, is that correct?
That's correct, yes.
But you have done arbitrations before.
That's correct.
But let's talk about your practical experience, not on the bench, but as a person who appears before the courts or before tribunals. What sort of experience do you have in that regard?
When I started my career early on, I did a fair bit of criminal work. I haven't done criminal work for many years, except when I was on the bench last. By and large, my practice has been administrative and constitutional over the last few years. When I was with the South African Human Rights Commission, I was a commissioner for 2 terms, and I did largely equality-related work for the South African Human Rights Commission, so that was constitutional work. And so my emphasis over the last little while has been on administrative law and constitutional law.
And if you should be appointed, what do you think you could bring to the KwaZulu-Natal bench?
Judge President, for the last 20-odd years, I had, because my job required it, had to think in depth about the Constitution and the provisions of the Constitution. And I think I will bring all that thinking and reflection to the job. And it also means, having had that heavy focus on administrative and constitutional law, that other aspects would have to be supplemented, and I'd have to ensure that I'm able to cope with that. But I think primarily that would be the contribution that I'll bring to the bench, that the knowledge that I acquired over that period.
Thank you, Deputy Chief Justice.
Thank you, Judge President. Mr. Premier.
Acting Judge President, I do not have a question at this stage. Thank you.
So, Mr. Premier, Acting Deputy Chief Justice, sir, but I do recognize that these concepts can be confusing. Thank you, sir.
My sincere apology.
Thank you, Mr. Premier.
I stand rectified.
Thank you, sir. Deputy President Maya.
Thank you, Deputy Chief Justice. Professor Govender, can I just bring to the attention of the Commission first that I had a brief pleasure of being tutored by you at UKZN, it was University of Natal then, in 1988. We were both much, much younger then. I just wanted to ask you further in relation to your experience in the area of criminal law. How many criminal law cases?
I'm sorry. May we? I'm sorry.
Could I put you,
Commissioner, I'm deeply indebted to you. I thought that my phone was switched off in the morning. For some reasons, I forgot to switch it off. I was actually going to ask you to switch your phones. Please, no penalty for me. If I was at the court, I would be penalized, but I'm deeply indebted to you for this. I'm sorry. Thank you, Commissioner. Thank you, President, Deputy President.
Thank you, DCJ. I was asking how many cases you adjudicated in criminal law during your acting stints.
Thank you, and thank you for the warm affirmation, Deputy President. I appreciate it. I think I handled about 3 or 4 matters, and then I had a particularly long matter, which the estimation to the Judge President was that it would take 2 weeks. I think it actually took about 6.5 weeks or so to finish. And so that was a rather long matter that I had to handle. And so I think I gave in total, in that period, about 4 judgments during the time that I was acting. Could be 4 in that ballpark. I can't remember, it's a few years ago now.
How did you find that experience? Did you struggle in dealing with those cases?
I think I was quite fortunate. I had a fairly competent counsel appearing before me, and I did not struggle. I thought, there were issues that I had to learn. I asked for one day to continue with the hearing until 4 p.m. and was told the next day that the prisoners didn't eat as a result of that. And so we had to finish at 3 o'clock. So there were many things like that I learned, but conceptually, it was not a struggle.
Commissioner Malema.
Thank you very much. Morning, Prof.
Morning, sir.
Do you know Professor Makhuba?
Yes, I do.
Is there anything you took from him since he was one of the leaders at the institution where you are?
He was the head of the university. I interacted with him occasionally, and my interaction with him was restricted largely to, I think I sat with him on a few selection committees, and we chatted. So recently when he heard me on the radio, he'd call and make a comment on something I've said. My impression was that he was a highly intelligent person, and he certainly controlled the meetings very effectively.
You're a professor of what?
Law, constitutional law and administrative law.
What does it take for a person to become a professor?
You have to publish, you have to acquire qualifications, you have to teach properly, and you apply for the post.
Let's deal with publication, one of the requirements.
Yes.
You have not published or written any seminal book of your own as an individual.
Yes, I contributed to 3 textbooks with other people.
You have not written any seminal book alone.
I have written something called The Educator of the Constitution, which was published by the Human Rights Commission and the Department of Education, KZN.
Let me ask it differently. Prof, have you written any seminal book alone?
I have written a book, Mr. Malema, and it's a textbook that's called The Educator and the Constitution. So that's the point I'm making.
Now, when it comes to qualifications, what do you have? What qualifications do you have?
I have a LLB I have 2 LLBs, a master's degree from the University of Michigan, and I have professional qualifications from the United Kingdom and from South Africa.
We agree that you don't have PhD.
No, I don't. That's correct.
And it's very rare for, especially in the university where you are, for black person, particularly Africans, to be professors without PhD.
It is now rare, yes. When I started, it was not.
Come again?
It was not a requirement when I started employment at the University of Natal. It is now a major requirement.
Now, Professor Makhoba then encouraged you guys to then start getting those types of qualifications so that you are complete.
Yes, that is
Now,
correct.
when you were appointed a professor, it was the law school was under Professor Michael Cowling.
That's not correct. When I was appointed a professor, an associate professor, that was the head of the law school was Professor David McCoy Mason.
And then Michael Cowling.
Yes, he was there in 2002.
And then when it was found that these qualifications are fraudulent, what role did you play?
I asked the university to give him an opportunity to respond to the allegations. I did that in an open meeting, which was, I think, it was a proposal that was accepted.
Prof, will I be correct if I say you were part of the people who defended Michael Cowling for when it was discovered that he had fraudulent qualifications?
The allegation was made that he had fraudulent qualification. He was our dean at the time, and my proposal to an open meeting of the university, of the law school, was that we should give him an opportunity to respond properly which was the proposal that was adopted. I didn't defend him in the sense of saying, because I had no information at the time. An allegation was made, and my proposal was, give this man time to respond, and he then decided to leave the university.
But when it was found that these qualifications are fraudulent, you still insisted that he was the right man?
No, I did not. What had happened was we were unsure of what the true picture was. So the whole idea was to treat him procedurally fairly and give him an opportunity to respond. That was my only major input into that process.
So now me and you can agree that Cowling is a fraudster. You agree?
He decided to take early retirement from the university, and to the best of my knowledge, he never provided a proper explanation in respect of one of the charges.
No, but the university where he claimed you obtained those qualifications confirmed that they do not know that those qualifications.
Yes, in respect of one of it, Mr. Malema, the position was that that qualification, as I understand it, could have been upgraded through an administrative process. And I think in the time that he actually went through that. In respect of the other issue, I think the university then indicated that he didn't have that qualification.
And to claim that you have a qualification you don't have, you are a fraudster. Do you agree?
It's certainly a major issue as far as academics are concerned.
Cowling is a fraudster. Do you agree?
Mr. Malema, I'm not sure. All I can say is that it should not have happened. It should not have happened at our university. But my only role in this entire process was that he be given an opportunity to be treated procedurally fairly.
So a judge is unable to tell me that a person who has been found not to have a qualification he claimed to have, you are struggling to agree with me that he's a fraudster.
What I'm struggling to agree with you is that I've never heard him respond fully to that particular charge.
The university said he doesn't have. You defended him even when the university said he doesn't have a qualification.
I didn't defend him. I said that all that should happen was that he should be treated procedurally fairly and that he should be given an opportunity to respond.
Are you registered for PhD now?
I am, yes.
Who's supervising you?
Professor Reddy supervised me.
Who's ready to you?
She's the dean of the law school.
Now, how can a dean of law school supervise you? You are his colleague.
Yes, the supervisor supervises you, and then the dissertation is marked by external examiners,
So you are supervised by your friend.
by a person who's the dean of the law school, yes.
Are you friends with Reddy?
Yes, we are colleagues and friends, yes.
And you are supervised by your friend?
Yes.
Okay, thank you.
Thank you, Commissioner Malema. I recognize you, Commissioner Ntlama.
Thank you, Acting DCJ. Professor Govender, good morning.
Good morning.
Let me also acknowledge that Professor Govender is my boss. He actually signed my leave for being here. Prof, I have one question. Considering your other experiences and the fact that I'm from the academia and I have deep interest for the academics representing the society, what makes you distinct as an academic as opposed to candidates that are in practice for the appointment to the bench? Thanks.
Thank you, Professor Laba. I think a decision was made, and it was perhaps necessitated by the circumstances that we found ourselves in, the absolutely undesirable and problematic circumstances at the time, that the pool of judges would be drawn from outside the ranks of senior counsel. You'll recall at the time in 1994, bar one, all the judges were male, and bar one, all the judges were white. So it was necessary for there to be a bigger pool. But I think I would argue that there are other important reasons for that people bring different life experiences. People bring a broader spectrum of events into the adjudication process. And I think it's probably conventional, or it's accepted now, that the first constitutional court that comprised practitioners, academics, judges, was a highly successful court. And I think the jurisprudence that emerged was informed considerably by the fact that you drew from various segments of society and various facets of the profession. So I think you will get a different experience from me. I will bring to the process of adjudicating the fact that I served 2 terms as a commissioner, the fact that I worked as an academic, the fact that I worked as an arbitrator. And so I think you'd bring all that experience, and the fact that I had the privilege of having generations of law students coming through the law school.
Thank you, Commissioner. Recognize Commissioner Ntlama.
Thanks, Acting Deputy Chief Justice. Good morning, Prof.
Good morning.
Please speak up.
In the last interview that we had with you, you were asked a question about whether you have done any motion court, and your answer was no. You were also asked whether you had done civil court, and your answer was no. After that interview, have you had any opportunity to act again?
Yes, that's correct. I did act again last year, and I, in that process, conducted motion court, and I heard civil appeals during that process. So I acted in the last session of 2015 last year. I was asked to come back for a session this year, but because of the issues at the university, I was unable to do so. But I did act last year.
Any civil appeals?
Yes, I heard a civil appeal during that time as well.
Thank you, Deputy.
Thank you, Madam Commissioner. The next show of hands that I recognize will be Advocate Helens, Commissioner Singh, and Mr. Nyambe, in that order.
Thank you, Madam Chair. Professor, in your application, You've annexed, as I see, one civil judgment, one criminal judgment, and one arbitration award. That's all. Am I correct?
I was asked for 3 judgments, yes.
Is it not a minimum of 3?
Sorry, I misunderstood that. I could have handed more, but
On the previous occasion, you handed in a rather lengthy judgment in a criminal matter, and that related to the lengthy criminal matter that you've referred to.
that's correct, yes.
Is there any reason why you didn't hand it in this time?
I just thought it was too long, and it may have just...
But you handed it in the first time, it was
Yes.
just as long then.
Yes, that's correct. I just decided to hand a different one in.
On the last occasion, I believe it was myself that raised some of the contents of that judgment with you. Do you remember?
I remember that, yes.
Do you remember the criticism made of that judgment?
I think you asked me, there was a first line in the judgment, when I said this was the judgment of the court.
A
And
unanimous judgment of the
Unanimous.
court. You were sitting with 2 assessors.
That's correct. And I think the criticism was that the legal issues were for me and the sentencing was for me.
Well, in the conviction, they comprised 2 components. One component is the findings of fact, which
Yes.
is very much a matter for the complete court.
Yes, that's correct.
The other were rulings of admissibility of admissions or
Yes.
confessions, correct?
That's correct. Yeah.
Was it correct that the whole court was in agreement with your ruling on the admissibility of the confessions?
Yes, I mean, clearly the issues of law are for the judge.
So,
What I did,
sorry,
can I go ahead?
no, carry on.
Yes, sorry, pardon me. What I did was I did debate the issues with the assessors,
The legal issues.
the legal issues, yes. But the determination was mine.
So in the decision-making process on matters of law, you involved the assessors who have no say on matters of law.
Yes, I debated the arguments with them and then made the decision
Do
myself.
you think that's proper when a judge's function is to decide the law on his own?
Yes, I mean, the decision I made was a decision I knew I had to make. I heard the arguments, and I heard the assessor's views on the point, and I finally made a decision on the law myself, which I justified in terms in my judgment.
But you went further than that. You said that the whole judgment, including the rulings of law, were made by the whole court, and that's legally not competent.
I'm not sure I said that, Advocate Helens. I said this is the unanimous judgment of the court.
Yes, and in the judgment were legal rulings.
But I'm just clarifying that the legal rulings that I made, the determinations on the legal rulings.
Thank you, ma'am.
Thank you, Commissioner Helens. Commissioner Singh. I recognize you, Mr. Malema, after Commissioner Singh, after Commissioner Nyambi, and the others. Thank you.
Thank you very much, Acting Deputy Chief Justice. I must also confess that I do know the professor. We both banana boys, so we come from the same area and we bump into each other quite often. Prof, I just wanted to know, you appeared here on 8th of October last year.
That's correct.
And then you had an acting stint at the end of 2015. And you did indicate in one of the answers that you were requested again in 2016. Did you not think that serving in an acting capacity would hold you in good stead because you knew you would be applying for this position rather than deal with your university matters at that time?
Thank you, Mr. Singh. I would have liked to have acted again, but because I have a certain position in the university, I had certain responsibilities, and there were issues that unfortunately I could not leave. So it was a decision that I made regrettably, but and I've understood the consequences. It certainly would have strengthened the application if I did it, but I had responsibilities which I just could not take care of.
Do you not think that this will be a general problem with academics? I know my good commissioner on that side talks about academics, being considered favorably, but do you not think that this will be a general problem that we may have with academics wanting to get onto the bench?
It may well be, but these are difficult times, and so it's not easy to say that this will be the norm going forward, but certainly in my case, it was extremely difficult given my responsibilities to take up the stint.
I think the chairperson of the meeting now did refer earlier on to the fact that the KZN Society for Advocates indicate, well, they've said here, and if I can quote, the general view amongst the membership is that Mr. Govender lacks sufficient practical experience but is hardworking and therefore has the ability to become a judge. And I think the Advocate for Transformation also said something
Similar things, yes.
something similar. But do you not believe that your, what I would call quasi-judicial experience, which you've had, will hold you in good stead if you're on the bench?
Yes, I think if you reflect holistically on what I've done, I've been an arbitrator since about 1997, a senior arbitrator from 2002. I've chaired the Film Publication Appeal Tribunal, and there's a track record of all the awards, judgments, and decisions I've given in the public domain. And I would argue that essentially I've been involved in the process of adjudication for a long while.
Two short questions, Acting Deputy Chief Justice. Middle Temple UK, barrister and member. Is that a membership or did you practice as well in the UK?
The way you qualify as a barrister is that you attend a practical course for a year, and then you write the bar examination in the United Kingdom, and then you join one of these Inns of Courts. So I didn't practice in the United Kingdom, no, but it's not something you just apply for. You have to attend lectures, write an examination, and then you're a member of that bar.
Your last question. In your questionnaire, item number 8, please furnish particulars of your membership of any political organization, past and present, and I'm looking at the Premier there, my Honorable Premier. You say name of organization, African National Congress, position held, ordinary member, and for period you say 6 months. Now I think the idea of the question was when, not necessarily the time, how many months. When was this, and are you still a member, active member?
This was around about 1994-95, and I ceased to be a member when I was appointed to the Human Rights Commission. This was part of the process.
Thank you.
Thank you, Commissioner Singh. I recognize Commissioner Nyambi.
Thank you. Professor Govender, are you able to speak any African language?
No, I'm afraid not.
Don't you think it's important to...
It is. I accept that readily, and it's one of my shortcomings.
What have you done to improve with that respect?
I did go to some classes, but did not persevere and prevail with that.
What is your understanding of judicial independence?
I think it operates at a number of levels. At the one level, judicial independence means that at the basic level, no one tells a judge how to determine a case. But I think judicial independence has evolved both in terms of the international best practices and certain terms of our law as well, to include security of tenure of the judge, financial independence, and institutional independence as well. And I think that all the steps that we are now embarking on in order to provide institutional independence is key, because ultimately an independent judiciary is pivotal to a functioning constitutional democracy.
If you can take us through the process of judicial accountability.
Yes, and I think you're right to link the two concepts. I think a judge speaks through his or her judgments, and the logic and the reasoning is then becomes part of the public domain, and you're then subject to scrutiny by academics like myself. You're subject to scrutiny by your members of the people that appear before you, and I think that's at the one level. That's that level of competence. I also think that as far as accountability is concerned, the Constitution provides that if you commit gross incapacity, misconduct, then there's a process of removal. And I think that the security of tenure requires that to be fairly restricted so that a judge can carry out their duties without fear or favor.
Is it right for politicians to criticize judges?
I think it's correct, but I think also that one has to understand, as someone said many years ago, that the judges possess neither the purse nor the sword, and that the level of criticism has to reflect that we are a developing constitutional democracy, and the things that judges have is the respect which they enjoy from the greater community. And I think that if the criticisms are such that it diminishes that respect, then it may ultimately have an adverse impact on the independence of the court. So I think I'm not one of those that says that every criticism should be permitted. I think the criticisms should have regard to the broader picture, that we don't have a legacy and history as other countries have. So I think, of course, criticisms are permissible, but I think that politicians must have regard to the broader picture. I'm sorry it's a long answer, but that's how I feel.
What about judges criticizing politicians?
I think that should not be gratuitous insults of judges criticizing politicians. I think judges speak through their judgments, and I think that the comments must be measured. It must deal fully with the issues, and I don't think it should go too far beyond the issues that you're dealing with.
Thank you, Acting Deputy Chief Justice.
Thank you, Madam Chair. Professor, you seem to, on page 15 of your questionnaire, indicate quite an illustrious juniorship, if I may say so, appearing at least 4 times in the Constitutional Court, around about the period 95, 96, 98. Then it seems to stream off. And then the next 2 cases you give is 2003, 2004. And then you seem in 2013, 14, 15, you get involved in acting again.
Yes.
You seem to have made, I'm just trying to indicate where I'm coming from. You seem to have made deliberate choices, either as a Human Rights Commissioner, your appointment, and wandered away from the practical side of law, or to your academic career. Am I correct?
That's correct, yes. Can I respond to that? I mean, when I got appointed to the Human Rights Commission, that was around about 1996. It meant that I had to deal with issues that came up for the Commission. And so a lot of my private practice then I didn't engage in too much private practice, and I worked on Human Rights Commission issues.
It's not due to a lack of instructions, because you appeared in this first certification case, you appeared in the State versus Zuma, you appeared in Unico case, you appeared in the mystery case, all Constitutional Court matters as juniors. Can I just ask, because that would hopefully assist me, is what, if you'd like to embroider on the decision not to act for a second time? You know, you attach importance to certain decisions, and if you can't indicate what the reasons were for not being prepared to act for a second term, if we put it that way, since appearing in October 2015.
2015, yes.
Would you like to embroider on those decisions? Why?
Well, it was simply because I had a position of responsibility at the university, and the session that I was asked to came in smack bang during the examination period, and I was responsible for ensuring that the marks came out for the courses that I oversee. I'm at the university what we call a unit leader, and I am in charge of the public law courses. So my responsibility was to make sure that all those exams were held on time, that the marks came out in time, and to oversee the academics that fall under me. If I walked away, then I would have had to get somebody else to replace that at short notice. It was actually a very difficult thing to do.
Thank you, Madam Chair.
Thank you, Mr. Commissioner. Notesi.
Thank you, Deputy, Acting Deputy Chief Justice. Prof, from what I've read, in the majority of cases, you are appearing as a junior. In most of the time, you have a senior that leads you.
In the Constitutional Court, yes, but I have appeared in other courts as well.
Yes, and as correctly pointed to you, you have very little time for the private practice. You have very little in view of your subsequent appointment as a commissioner and the academic career.
Yes, I think that would be correct, that I tended to do focus on the Human Rights Commission stuff and my arbitrations and previous.
Would you agree with me that the writing of a judgment, we have just acted as a judge, the writing of a judgment itself as a judge, it requires skill
yes, I
and
agree.
an experience in writing.
Yes.
And taking into account that long judgment, that you were taken through by Commissioner Helens, that long judgment, of course reflective of the duration of the criminal case itself, would you say confidently that you are ready to be judged in view of the limited experience to act, also the absence of experience in practice?
For your answer, Mr. Govender, Commissioner Helens, please switch off your mic.
Yes, with respect, I would say so. The length of that judgment was dictated partly by the number of issues that I had to deal with. I've been writing in the public domain now for many years, and if you look at the judgments that I've written, you could make a determination as to whether or not I could coherently and logically draft a judgment, and I think that is one area that I have experience in, that I can write.
Lastly, the involvement of assessors when you dealt with issues of law, where you were to make rulings on questions of law, would you agree with me that was occasioned by your lack of exposure in the practice now, in the practical side of the law?
No, I won't agree with that, Commissioner. I think what I wanted to do was I had the arguments made to me, and I just simply wanted to debate it with people. It wasn't to do with a lack of experience. They were there, and I debated issues with them. And I finally made the decision on my own.
Thank you, Mr. Commissioner. Mr. Malema, you raised your hand. Are you still
just
interested?
a small one. I forgot to raise an issue. What's your take on corruption, Prof?
I think it's a major issue.
Press.
It's something out of great concern. It really can erode the fabric of our society and undermine some of the key notions upon which this constitutional democracy is based.
Did your brother practice and got a renovating tender in the law school? While you are a senior employee and a friend of the dean?
I have no idea what his company did. I had nothing to do with his company.
You have no idea that your brother's company got a tender to renovate some buildings in the law school where you are a senior staff member and a friend of a dean?
Yeah, the law school itself, I'm not sure makes decisions, but I certainly I have no link with his company, and I have had no part whatsoever in any decision making. I think the university procurement processes are done centrally, but I have nothing, no link whatsoever with his business or with the decisions.
Commissioner Malema, Chairperson Modise.
Thank you, ma'am. Professor, you earlier on said, and you just again said, that you just wanted to discuss. Did you want to discuss what you said earlier on, that you knew the ruling you were going to make, but you just wanted to, why? Were you not sure of what you wanted to?
The purpose of this is you have people that are available. As a judge, there are very few people you can talk to except other judges. And so when the arguments were made to me, I debated it with my assessors and then made the final decision. So it wasn't a question of not being sure. I wanted to articulate it, think about it, and then make a decision.
What then is your take on judicial dissent?
I think dissents are important. I think that what dissents do is they create an alternative view, and in time that could grow the jurisprudence. I think it's very important that there be dissent, because it demonstrates that people are thinking at different levels. And sometimes, and we've had this in our history, where a dissenting judgment has become a majority judgment.
Okay. What's your take on the view that the courts have a duty to avoid encroaching on the powers of other spheres of government?
I think the doctrine of separation of powers is a very important principle in our constitutional dispensation. And the Constitutional Court, in a case called Mazibuko, elaborated on this. And it indicated that one of the reasons for that is that you don't want to encumber those that exercise public power, particularly the executive and the legislature, unnecessarily, because ultimately the electorate holds them accountable in elections. So the separation of powers is an important principle. Simultaneously, the court is also given the power, in terms of Section 172 of the Constitution, to determine issues of inconsistency with the Constitution. And so I think what a judge has to do is to be cognizant of the doctrine of separation of powers, but also understand they have a solemn responsibility to make a determination as to whether or not a particular law or conduct is consistent with the Constitution. And I think it's managing those sorts of issues that calls for a judicial determination. So the doctrine of separation of powers is a particularly important doctrine, but is one of a number of doctrines that the judges have to exercise a judicial discretion as to how to reach a determination, having regard to these various factors.
But isn't discretion a very subjective term? I mean, how, when you teach, Prof, and you teach on separation of powers, how do you draw the line?
It is difficult. But what you have to do is you have to have regard to the factual context with which you're dealing with. You have to have regard to the contravention of the Constitution you're dealing with. And you have to have regard of the terrain that the Constitution has afforded to the executive or the legislature. And it's really having to have regard to all these factors. What you can't say, for example, is that the separation of powers will always trump other factors. It's a matter of having regard to all the key constitutional concepts that you've got to think about. And you've got to be particularly aware that the doctrine of separation of powers is, firstly, it's about not trespassing upon the terrain of another organ of state, but it's also about preventing an unhealthy amalgamation of powers. So it's a whole series of factors. I'm afraid it's a bit of a theoretical answer, but that's how you can't, this concept is difficult, and you have to have regard to a variety of issues before reaching the determination.
Thank you, ma'am.
Thank you, Madam Commissioner. In the absence of any further question, I beg your pardon, Madam Commissioner. I beg your pardon. I do recognize you now.
Thank you, Madam Acting Deputy Chief Justice. Professor, good morning.
Good morning.
You appeared before us on the 8th of October 2015, and certain questions as regards your practical exposure, both as a practicing advocate and as an acting judge, were put to you. So based on what emerged then, I just want to ask you one question. In the intervening period, i.e. between the 8th of October 2015 and today, did you serve as an acting judge in the criminal courts or not?
Not in the criminal courts, no.
Yes. Which means, therefore, that what you are presenting here today as your experience as far as criminal law practice is concerned is the same as what was presented to us on the 8th.
I think the criticism previously...
No, I'm talking in terms of you getting exposure and experience over and above that which was presented by yourself here on the 8th of October 2015, if that makes sense.
Yes, I understand what you're saying. I had a further acting stint, as I pointed out, in towards the end of 2015. So that was the material difference between that and when I first appeared.
That experience, if I understand you correctly, had to do with motion court practice and civil appeals, and it had nothing whatever to do with criminal trial practice.
I had a number of criminal appeals during that period as well.
In terms of criminal trials, live trials,
No, I
did you
didn't- I
have
didn't
any
hear.
further exposure beyond that which you presented here on the 8th of
No.
October 2015?
The only criminal matters I heard during that period was, I think I heard about 5 or 6 criminal appeals during that period.
Very well. So when we assess your candidature or your fitness or otherwise, qualifications or otherwise, we will be well advised to take into account that which emerged on the 8th of October 2015, insofar as criminal
Yes, as
exposure is
supplemented with the
concerned.
appeals that I heard subsequently.
Thank you.
Thank you, ma'am.
Commissioner, Mr. Govender, as a young lawyer, you were privileged to be a junior in the litigation pertaining to, or rather that was central to the establishment of our constitutional order, the first certification case, in which the Constitutional Court reviewed the new text to make sure that it was in line with the constitutional principles. You were also involved in cases such as Mystery, State versus Zuma, etc. What I found quite intriguing, as at that time, as a junior counsel and black lawyer, you decided not to proceed with that kind of a career when the country needed people like yourself, who had such a privilege to begin at that constitutional order time to assist in the development of our jurisprudence. I was quite intrigued by the fact that despite the opportunity and privilege, you decided not to pursue your career as a full-time advocate to assist the country and the courts in developing our jurisprudence. Do you have a comment?
Thank you. You are indeed correct. It was an immense privilege to be involved in those cases. I applied for a position on the South African Human Rights Commission at the time, and I got the appointment, and I spent 14 years as a part-time commissioner on the South African Human Rights Commission, and it was for that reason that I didn't engage fully in practice during that period. I would argue that I attempted in the South African Human Rights Commission to make the sort of contribution that you've referred to, and I was part of the very first commission that was appointed, and we had to, under Dr. Bani Patiana, and we had to set up the commission. So it was for that reason that I didn't pursue the path that you've identified.
As a lawyer who was involved at that stage in defining the constitutional principles of the new text, are there other imperatives of the Constitution that you think may still have to be developed or properly interpreted in line with the first interpretation in first certification case?
Yes, I think that the interpretation of the Constitution is an ongoing thing. And if you look at the most successful constitutional democracies in the world, they are those that have a whole body of jurisprudence that develops on each provision of the Constitution. And what we've been doing over the last 20 years is actively thinking about key constitutional concepts and actively litigating on it. And I think that that is absolutely crucial to our development as a constitutional democracy. And so I think there are many things that are going to continue to be developed, whether it is in respect of the principles of legality, whether it's in respect of the development of the Bill of Rights, or issues regarding accountability in respect of the exercise of public power. I think all those concepts will, over time, be developed. I think in the first few years, with respect, I thought the Constitutional Court adopted the correct approach, which allowed for an incremental development of the various rights. And what you, I think, needed is for each right to develop independently and not allow a generous or far too generous interpretation to one right that would impede another right. But I think a lot of that's been established now, and we can take it to the next level. So I think what we have been doing is working on this text. I take the view that the jurisprudence that's emerged is an enviable jurisprudence. It's quoted by courts throughout the world, and I hope that we continue doing so and realizing the broader visions of our Constitution.
One of the few lawyers who have had that privilege that I spoke about, and when you stand back, given those constitutional principles and see the development of the law and the jurisprudence of that has been developed by the court, in your view, which of the judgment do you think the court has probably got wrong?
Got wrong? All the judgments that I lost. I was hoping you'd ask me which of the judgment I thought the court got absolutely right. I have to think about that, Justice Govender. There may well have...
Can't think of any, it is okay. From time to time, I do ask the new clerks at the court that you have to look at the judgment very critically, and there may be judgments that the court get wrong, and we're open to that kind of criticism.
Yes, I suppose if I was pushed, I'd probably look at a case like Jordan, and I'm not entirely sure that the equality principle was best served in the Jordan judgment. But I think the circumstances were difficult in that case.
Mr. Govender, it doesn't appear that there's any other commissioner who would like to ask questions. Is there any comment that you'd like to say or
No,
add
I'm very grateful for this opportunity, and I'm obliged to you for affording me this courtesy. Thank you.
Thank you, sir. Let me thank you for making yourself available again. You are excused.
Thank you.